Thanks everybody for giving your time tonight to come along. It's been a little while since I've had to do one of these, so hopefully we've got it all together tonight. I'm Justine Hanks. I'm the Education Manager at Rule of Law. If I haven't met you before or I haven't seen you before, a few people's names I've recognised from court visits or from emails and from the LSA conference. So welcome. With me tonight is Sally, who's going to give you a wave. She's our CEO at the Rule of Law Education Centre. So tonight, I just wanted to do a bit of a re-presentation. For those of you that saw my presentation at the LSA conference, I didn't get through enough of it. So we're going to be finishing it tonight. And for those of you that weren't there, it's really good to be able to share with you the information and the research that I completed with regards to these competing needs in the justice system. I've got a little bit of a croaky voice, so I'm just going to keep powering on through tonight, but let me know if there's any issues as we go. You can feel free to pop questions in the chat if you want to. Sal's going to monitor that for us. No need to have your cameras on. So let's get going, I think. So essentially what interested me about this is I know that there's a real lack of, from my time teaching human rights, not a huge lack of resources, but it's a really hard topic to teach, and it's a really challenging area to understand sometimes the aspects of it and the nature of it. So I really wanted to create something that helped to examine human rights from a slightly different perspective by incorporating it into other topic areas, not as a standalone topic. Often human rights as a topic is treated a little bit like an island, I think, as a standalone kind of unit, and particularly as students tend to think of it that way. And I think it's really helpful to be incorporating those principles all the way through and those concepts all the way through, particularly when it's part of our LCMIS is what I used to teach. I know some people use LCMID. But it's good to also be able to link those concepts to the rule of law principles as well, and to incorporate those rule of law principles all the way through different topic areas. So welcome. So for those of you that are unfamiliar, although I believe you're probably all pretty familiar with our rule of law wheel, what we tend to focus on in our organisation, anytime we make a resource, there's two aspects that we look at. Firstly, we look at whether it achieves equality and fairness and whether any of the principles are impacted, and whether those principles are being protected and given, and people are being given the opportunity for equality and fairness in Australia and elsewhere. And the second thing is where does it fit into the syllabus for us, because we want to make it as usable as possible. We do have teacher members from across Australia, so we're trying to write things that fit across syllabuses, which can be challenging as well. But we're trying to fit a lot of people's needs in terms of the way that we create different resources. So tonight we're just going to cover a little bit about the rule of law and human rights and how they are inextricably linked. Then we're going to look at some case studies, and I've tried to follow kind of what syllabuses do in terms of looking at accused offenders, complainants and victims, society and the community as sort of three main areas that we look at. So this statement's taken from the preamble of the UDHR and establishes for us the very clear link between human rights and the rule of law. In order for people of nation states not to have reasons to rise up to improve their situation or to rebel against the government and systems in place, all rights have to be protected by the rule of law, essentially. So people should all experience equality and fairness, and they really have no need to rebel against authorities or against legislation that's being created or conditions, societal conditions, if they're all experiencing equality and fairness. And that's the existence of the rule of law. So the rule of law real that we saw before gives us all those foundation principles that should help us to create those conditions of equality and fairness, provided that each is well represented and protected by the arms of the separation of powers, and that people feel like they're able to participate and create change in their own community as well. They're often treated, human rights are often treated as a contemporary idea, but they've really been around for a really long time. So there's evidence of their existence in some ancient societies. For example, there's written text dating all the way back to 2000 BC from Babylon and ancient Egypt that served to protect rights and protect the weak from the strong and ensure that things were done in accordance with the law. Classical societies also had some protections for some individuals, such as the Greeks and Romans. And we also see lots of evidence through the oral histories of Indigenous Australians. So there was this very strong concepts of justice and rights. And a good example is perhaps the right to information in Indigenous culture, where there's the oral passing down of traditions and rules and regulations and things like that. And there's a really strict classification system of secret information and public information. Information is then shared. Tara, you can't. Does that mean you can't see the PowerPoint?
So mine, if I'm in gallery mode, Justine, I can see your slides. It depends on your mode.
Okay.
So if I go, I don't know about other people, but if you go into, for me, meeting views and into gallery, I see your screen, your PowerPoint. But if I go into large gallery, I don't see your PowerPoint. I don't know if that's the same for everyone else.
Because I'm in gallery mode, so I'm not sure. So I can see it. Can everybody else see it? Can you just let me know? Yeah, I'm getting some thumbs up that people are okay. So maybe you might just need to switch your view there, Tara. Okay, no problem at all. Tara's going to log in and again. Sorry, guys. So switching through time, the development of Magna Carta, we of course saw one of the most prominent written recognition of rights. It's continued forward today into Western culture and Western societies mostly. There was also a lot of thinking about natural law in the 17th and 18th centuries. So William Blackstone, particularly in the Blackstone commentaries, philosophers like John Locke and Immanuel Kant did a lot of thinking about natural law. And basically the concept of natural law comes from being in a state of nature, according to Locke. He called it a state of nature, that people were not of a certain status or particular place but had rights and were living ungoverned. So therefore natural law was believed to exist above rulers. And so there were certain rights that should be afforded to people just because they were human, simply because they were human. So very early origins of this concept that we rely so heavily upon today. Locke also imagined that people had come together to agree on a ruler or a government, and that body was to be responsible for protecting individual rights. And so there was a contract that was formed between people and their government. And if rights weren't protected and upheld, then people had the right to reform or remove the government because the contractual terms were broken and the contract was then deemed to be ended. So it's really interesting to read about those origins of human rights. So in a contemporary context, the codification of human rights through various international documents after World War II has seen the creation of that framework that makes rights measurable in terms of achievement. Whether a nation's a signatory or not to an international document doesn't seem to matter when we're evaluating the performance of nations in a human rights context. Countries are generally judged for not being signatories to different documents, and signatory nations are judged for breaching their human rights standards that they've agreed to undertake. So whether or not you are part of that codification doesn't seem to really matter in our criticism of different nations as much as it could. Sorry guys, I'm having mouse issues. Technology loves us tonight. So the other thing is that there is, in a lot of the writing and a lot of the research, there's a distinction between rights and freedoms. And there is a difference between the two. So rights are generally positive in nature. They enable people, they give people an enabling to participate or engage in an activity or receive a certain benefit. Often if they deal with interpersonal relationships, they're protected by tort law or other laws that can remedy a breach. For example, contract law, so the right to be paid for the work that you've been undertaking. Freedoms such as freedom of movement and assembly are not usually enforceable unless they can be classified as an actionable wrong before the law, where individuals can have certain recourses. They tend to be negative in nature, so they provide freedom from interference by the government. But we've seen, and there's an example that we'll look at a little bit later, in Victoria during COVID-19, that governments can revoke these freedoms based on different circumstances. So I don't know how big that is. It was a lot bigger on the screen at the conference, but a lot of you have said you've received your posters anyway tonight, so you will have seen this. Slightly it's just an A4 version instead of the A3, the landscape version that we sent out. But essentially, we created a new resource because we wanted to establish an explicit link between human rights and the rule of law principles. So at the centre of the new wheel is our rule of law wheel with all of those principles, and no one is above the law, that concept. And then around the wheel, we see there are the various international documents and the supporting articles from different documents that help to protect those principles of the rule of law internationally. So we've tried to make it in a way that creates cross-syllabus links for human rights, which I think many students, like I said before, inherently consider human rights as being a bit more of a standalone unit, and they tend to do a lot of siloed thinking around human rights. And so any way that we can kind of engage them, you know, it's easy in something like family when you look at the croc, but sometimes it's a little bit less reachable, and I think we tend to forget about it in terms of topics like crime, for example, where we could look at a little bit more human rights in a bit more depth. I keep losing my mouse and I don't know why. So annoying. Reverting to a touch screen. So in terms of thinking about human rights and the relationship between rule of law and human rights, there's also this issue about democracy. So when we think about the rule of law and human rights, we find that democracy is actually a very effective way of protecting both of these concepts really strongly. So what I wanted to capture in this diagram was that democracy achieves equality, rule of law achieves equality, and human rights also achieve equality. But then in order for democracy, for human rights to be protected and enabled, we needed democratic conditions, and same with the rule of law, and then the same with that relationship between the rule of law and human rights. So we've got those relationships there between having the rule of law there to protect human rights, and human rights enabling the rule of law, that protection of human rights enabling the rule of law to occur safely and to be achieved, and all those principles to be achieved. Following from that concept, I wanted to also show that link between the three. So our geography teachers everywhere love a chloropleth map. I always get to say that wrong. Dealing with the prevalence of democracy, the recognition of rights, and the function of the rule of law, we can see there's a really strong correlation between more democratic nations and the prevalence of the rule of law and the recognition of human rights. So I've put a reference in there. You should be able to see it much more easily if you download the PowerPoint from the website. The link was in the meeting chat right at the top, but you can just jump onto the website and download that. But this is we can see those correlations through democratic nations, even those flawed democracies that, as identified by the democratic, the state of democracy map there, have the greatest representations of the rule of law and human rights compliance. So even in those ones that are not, you know, high level full democracies, we see that there's still protection of those. So in terms of Australia, I think for some of you that were at the conference, you might have seen Lorraine Finlay, the Human Rights Commissioner, speaking, and she covered a little bit of this next slide here. So how are human rights protected and enforced in Australia? And I wanted to just briefly touch on this, but we see that there is some explicit, we know that there's some explicit and some implicit recognitions in the Constitution. Some are covered by statute law. So once we've gone through that process of ratification, we have enshrined some in statute law. But most commonly, the protections often come from common law and from our judges. So things like presumption of innocence, procedural fairness, those rights are captured by the common law very particularly, and the independence of the judiciary really is something that protects a lot of those rights and freedoms in Australia. We have a new resource that's almost complete on the principle of legality that's coming out if anyone's interested in that coming forward. There's a few cases that I know are in textbooks and things like that are stated there. So Toonan versus Australia, so having that right to a private life. Teo's case from 1995 as well, which established that individuals were entitled to fundamental rights where Australia is a signatory. So all of those protections that we've come through in precedent are things that we value really highly and that have had really strong protection from the common law. So where there is the debate at the moment going on about whether a Human Rights Act is the right way to go, but I think there's a real lack of emphasis on the fact that we actually do have a really quite a good, despite some big tarnishes, we don't have quite a good human rights record compared to other nations in Australia, and a lot of protections inbuilt to our system already. So what are the obstacles that we have in protecting human rights in Australia? So there's a lot of issues here. I'm not going to unpack all of them. But I think a particular concern to us as an organisation, and this is something that we've been doing a lot of focusing on in the past 6 months particularly, is that declining trend in participation in democratic processes such as voting and referenda, particularly by our young people. There's a real lack of civic knowledge amongst our emerging voters that's coming through in the civics test, the National Civics Test. We know that only about 51% of young voters, 18-year-olds, are turning up to vote. That's happened at the last 3 federal elections, and we're waiting to see some data from the referendum. But those young people find or feel, a lot of young people feel that turning up to protest in the street with a placard is a much more valuable thing for them to do than coming and putting some numbers on a piece of paper. And so there's a real disconnect there in getting people to engage in those systems, getting our young people who are the future, older generations, getting them to engage there. And that's something that is an obstacle for human rights, because if we don't get people turning up and voting and expressing an opinion, then we run the risk of losing some of those protections of our rights and losing some of the protections of the rule of law principles as well. So that's probably a really big thing that we're really engaged in at the moment. We've been fighting really hard for an increased presence of civics in the curriculum, particularly in New South Wales, and making lots of submissions to syllabuses that NESA has been drafting. I think also one of the most pressing issues for our executive, if we're thinking about the separation of powers too, and how that's an obstacle for human rights in Australia, is getting that balance right between all the competing needs in such a diverse community. We've got lots of competing cultural and social needs and expectations, and policy making is always necessarily going to be difficult as a result of that. So I think we need to acknowledge that there's also an inherent motivation of government is typically towards what's going to achieve another term for them as well. So there's a bit of a balancing issue going on there. If we think about needs in our justice system in terms of getting rights protected, if you think about the example of there's a recent re-emergence in New South Wales of a tough on crime stance. This is particularly coming out with those proposed bail amendments before Parliament to do with young people and bail, young offenders and bail. So it's arisen essentially in response to high rates of regional crime, particularly car thefts and break and enter offences. As a side note, I know people who were at the conference might have heard this story, but my husband and son went to the State Touch Football Cup last February, and it was in Dubbo. And of the participants, 21 cars were stolen and 4 were torched, I believe. So that is a huge amount for participants in a tournament that are visitors to the area, and that impacts upon the local community really heavily, just in their everyday life, but it also impacts upon tourism and economically. So it's a really big deal. Boxar's latest statistics show that there's been a 20% increase in car theft offences between 2019 and 2023 in regional New South Wales, and considering that that's quite a big proportion, considering that a couple of those years were spent in a lot of lockdowns and with people unable to travel around. So the bail change is going to make it much harder for 14 to 18-year-olds to make bail if they're charged with either of those types of offences when they're actually already on bail. And so there's a new offence as well that's being created, and it's going to be inserted into section 154K of the Crimes Act, and that's referred to as the post and boast. So if they commit these offences and post it online, they're going to be liable for a maximum sentence for the offence committed, plus another 2 years imprisonment on top of that if they post and boast. So it's quite a heavy penalty as well for our young offenders. And essentially, in terms of thinking about this as a policy, it contravenes Articles 3 and 19 of the CROC, so the best interests of the child. And we know that children incarcerated at a younger age tend to be lifelong participants in the justice system. And a lot of issues that they already have tend to be exacerbated by incarceration. It also touches on Article 14 of the ICCPR, so that with regard to procedural fairness and the presumption of innocence. And it's also encroaching on the independence of the judiciary in the use of their discretion to acknowledge mitigating factors as well. The other problem, though, when we look at that conflict between representing, different rights in lawmaking, what about the rights of the victims? They should have the right to feel safe in their own communities. These communities should not be subjected to high rates of crime. And there's also then a community aspect of, well, could that money needed to draft that legislation be used to enhance those communities and engage young people differently in different ways? So could it be used for better community policing that serves the needs of that community a little bit better and helps to establish community relationships? So there's all of that balancing act going on by our executive when they're trying to make law. So for any economists out there, I don't know if there's any economists out there, I'd like to see a show of thumbs if there's some. In terms of policy making, one of the, thanks Christy, one of the largest juggles that the executive faces in making decisions about juggling different needs is competing policy motivations that we have too. So domestic policy decisions in economic terms tend to be what we call Pareto optimal in focus. So they're aimed at increasing resource efficiency and creating the best allocation of resources for our community at that present time. But when we make a change in those policies, what tends to happen in Pareto optimality is it creates a better situation for some, but leaves others worse off. So there's an aim that we want to increase social utility overall, but someone's going to suffer as a result of it. And that's how we create the policies that regulate our justice system and the laws that regulate those behaviours. So they're created with that resource efficiency in mind and that social optimality. The issue is that with international law, when we look at human rights law, that operates as game theory more than anything. So we're looking at a Nash equilibrium there. And so if anyone saw A Beautiful Mind, you might remember Russell Crowe playing John Nash. But you're looking at your classical prisoner's dilemma kind of game where the state chooses compliance or not based on the expectations of what other states are going to do, so what the response is going to be. So what's happening is we have an internal policy conflict with external influences in terms of trying to create policies domestically that adhere to the international laws. But then we're also thinking about, well, do we comply with those international laws, because it may or may not suit our community at that particular point in time, but it could lead to retaliation from other nations in several different ways if we don't. So there's that juggling act is going on as well in the executive. So if we think about those different groups just briefly, so whose needs are the arms of the separation of powers juggling with when we think about justice and the justice system? So we're looking at accused persons and offenders and victims and complainants, so those participants to matters at the courts. So how will upholding one party's rights impact on the other party? And will those decisions have implications for future participants in the justice system, particularly when we're creating precedent? The differing social groups that we have in our community, so based on gender, race, age, culture, income level, etc., etc. We have current and future community members as well. So when we cater to one group, or how are the other groups impacted? Is it negative or positive? What are the needs? Which groups' needs are we going to prioritise when there's conflicts in rights? And how do we prioritise them based on current social conventions? Are they based on political interests of the time of political parties? It's probably a combination of both, realistically, but is one sort of influencing more than the other? And our community, so local, domestic and global communities, what scale and impact will a decision have? And when we think about, again, decision making in terms of compliance with human rights laws, it could have a much greater scale than we actually understand. We might be thinking we're making a local community decision, but it actually has a much bigger implication for our global relationships sometimes. The important point here is that equality before the law will assist in meeting human rights obligations. So it will help us to create the conditions for a greater number of rights to be recognised. So I think that's a really, really important point to remember. So let's have a look firstly. So I just tried to classify it into those three groups, basically to make it a little bit simpler to follow and a little bit more usable, hopefully, syllabus-wise. So there's so many competing issues and interests when we look at accused persons and offenders and their treatment and their human rights and getting compliance. I had to force myself to choose some battles and stick to one slide. So that's why this slide is quite crowded. So let's start with bail. We touched before on the issues with the proposed bail laws, but this is perhaps one of the most widely publicised and contentious areas of the juggle that we see. Judges and magistrates we see at Law Day, our program, all speak about how, for most of them, bail is the most difficult decision to make, particularly given the potential impact on other parties and the public expectations that differ from the parameters that they're required to work in to uphold the rights of the accused and the interests of the community. So to give you some statistics, I looked at the latest reports from Boxar, and they can all be found on the website, on their website, on Boxar's website, under the Publications and Evaluations tab. They release reports with court statistics and things like that with a big Excel spreadsheet that you can download and have a look at, and you can move it around and browse. Just browse by subject for courts. So in the year July 2022 to June 23, across all courts in New South Wales except the Supreme Court, 10,929 defendants were bail refused overall. And of those 10,929 who were bail refused, 294 offenders subsequently had all charges withdrawn by the prosecution before it reached the court. So that's quite a large proportion of people who are spending time incarcerated to have all charges withdrawn. Of those 294 offenders, 28 of them were children. So 28 children spent time on bail, not on bail, refused bail and spent time incarcerated and in custody with all charges being withdrawn eventually. So that has really big implications for our presumption of innocence. It has big implications for fairness as well. But on the other hand, when we're juggling those rights, well, what about the rights of the victim? What about the rights of the community to feel safe? So that's a bit of a juggle that we're looking at. Of the 33 people that were bail refused in the Supreme Court, arrest to finalisation was sitting, so that the time between the person's arrest and the finalisation, so when they go to prison, essentially for that offence, is 822 days. So it's about 2.2 years. So for that group of people, for those 33 people, 3 people were acquitted of their charges. So they spent roughly 2.2 years in jail to be acquitted in the end, so about 9%. In the district court, of 100 people that were bail refused, it was about 764 days from arrest to finalisation, and 16 were acquitted. So it's not a huge proportional percentage, but it is still quite a significant number of people who are impacted quite heavily by that happening. And we'll talk a little bit more about that later. In the Children's Court, if we looked at matters that proceeded to defendant hearings, so where the accused defends a charge through their lawyer, there were 128 children that were bail refused in that time period, and 44 were found not guilty of all charges. So that's a much bigger proportion of offenders that are not actually acquitted eventually. And it's around 421 days from arrest to finalisation through the Children's Court. So when we look at that delay, that time delay, that is a really big issue in terms of human rights and in terms of the rule of law principles. Expediency in dealing with matters is something that we need to make sure happens in order to reach a just outcome for our offender, that things are finalised and that they can move forward with whatever it might be, whatever the punishment might be, or whether they are acquitted or not. So that's something that we're really is a really prominent thing in our system. But we're so stretched for resources as well in the legal system that it is really difficult to expedite those matters anymore. And remember, that time period as well is also a hangover from COVID. There's a lot of cases still hanging over from COVID in that time period as well. So there's still a backlog. There's accounting for some of those delays. So all of these kind of delays and things like that have real implications. If we think about our young people in terms of the ICCPR Article 9, Part 3, deals with promptness of having your matter dealt with promptly. And Article 14 looks at the rehabilitation of young people being the priority. There's also presumption of innocence implications and implications under the CROC. So if we think specifically about the CROC, inside that convention itself, there's also conflicting rights. And so the provisions under the CROC, Article 40.1 recognises the need for community safety as a sentencing consideration in matters with juvenile offenders. But also then we've got Article 40, so 40.4 has a range of sentencing options and alternatives to avoid institutionalisation for young people to the greatest extent possible, and proportionality and ensuring children are dealt with in a manner appropriate to their well-being and proportionate to both their circumstances and to the offence. So we've got this community safety has to be a priority, but we've also got avoiding institutionalisation to the greatest extent possible, and those conflicting together within the one convention. So how do we determine what is our priority as a community? And that's often the executive's call. And we can see that through these bail law amendments that we've got happening at the moment. If we think about CDOs and ESOs, these have actually been in the in the media lately because they're under review at the minute. I just need to turn the chat off. It's just distracting me. We have a new resource about post-sentencing considerations of CDOs and ESOs, so continuing detention orders and extended supervision orders as well. There's a few cases that we have in this resource that we've used that we've focused on. So Rebecca Butterfield, so she was a violent offender with serious mental health issues. Abdul Nader Ben Brika is a terrorism offender, and then Ghazawi is a child sex offender. So when we look at CDOs and ESOs, they're used for the safety of the community in relation to extreme offenders that have shown no sign of rehabilitation or positive change while serving their head sentence or their total sentence. And effectively, in this situation, a civil order is being used to extend a criminal penalty on the assumption that the offender will reoffend in a particularly serious and dangerous way. We've seen in Perth recently something that's not the same situation, but certainly related to it in terms of our the offender that was released from immigration detention. So this raises questions of fairness and procedural fairness. Those decisions are not based on evidence tested before the court, but tend to be expert evidence and opinions of experts about recovery and things like that. If we think about strictly about human rights and strictly about rule of law principles, they're in conflict with the consequences that are raised as a result of the breach. So ESOs carry criminal penalties for a civil order. So if someone breaches an ESO, there's a criminal penalty associated with that. But if we compare it with conditional parole, which is a similar program for less risky offenders, there's a civil penalty, which is just returning to jail. And it doesn't carry with it a record increase or an extra penalty or an extra fine. The other issue is that these offenders have often done their time and served their sentence as determined by a judicial officer, using their discretion and accounting for aggravating and mitigating circumstances. So there's a question about whether it undermines confidence in the justice system as well. Sorry, everybody, I'm just going to have a quick look at the couple of comments that came through in the chat. Yep, Christine, I do agree. I do agree serious law enforcement training for New South Wales police staff is needed. And I think that that's definitely a resourcing issue. And I can't imagine to live that experience. But absolutely no way I can understand that or can understand the impact that it has on communities. So I do agree with you. Okay, sorry. So historical child sex offences, so female offenders. So the recent judgment in Lamb VR in the New South Wales Criminal Court of Appeal created an acquittal for a female offender, as the Act at the time of the offending didn't recognise the actors in the legislation at the time didn't recognise female offenders as being perpetrators of sexual assault against male children. The offence was came under buggery, and it was deemed to be only related to men. So this appears here because there's an important rule of law principle that people can only be punished in accordance with the law at the time. And that's also part of the UDHR under Article 11 and the ICCPR under Article 15, that you can only be punished in accordance with the law. So in terms of an offender at that particular time, there is issues of breaches happening under those different articles. Gay Grant is another offender that's also appealed on the outcome of that case, and it hasn't had an outcome yet, her appeal. It was heard in the last couple of weeks. There was talk that the outcome was going to be before the end of April, but we haven't seen anything as yet. But she's believed it's going to be likely that she will succeed based on the outcome in Lamb VR as well. Remember that I'm only looking at it through the accused or offender's eyes at this particular point in time, but I do appreciate there's another side to the story which we'll come to when we get to our victims side in the next bit. So consent laws are something at the moment which is really, and for the last sort of 4 or 5 years have been really a topic of talk and reform. Again, perhaps part of a tough on crime approach by the New South Wales government, but reform was certainly needed in this area. How to reform becomes a really big issue when most of the interactions only involve two people, the defendant and the complainant, and that becomes really, really difficult. And a lot of the judges do comment on that, the difficulty in cases where there's really just two parties to the matter, two witnesses, and a conversation, essentially. So these cases under the consent laws are only just starting to come before the courts in the past 6 months. There's already been issues that judges are starting to flag with the law, the way that the legislation has been written on LDLOs, particularly with female judges. They're really stressing to young people, that the students that they're talking to, that they have to keep asking for consent basically every minute or two, or every time an activity changes even a little bit, in order to protect themselves against prosecution. So they're telling them very clearly that they need to ask explicitly the question consistently, constantly. If they're kissing, one of the judges said, if you're kissing, then you say, is it still okay to kiss you? Before you kiss them, you have to ask if you can kiss them, that kind of stuff. So there's a requirement. The judges are saying that there really is a need, the way that the legislation's been written, that you have to ask constantly and consistently. And whether that's a bad thing or not, I don't know, but it's certainly something that they're saying is causing a great deal of conflict. The law, as a result of the way that the law has been written, it appears that there may have been an unintentional shift of the onus of proof onto the defendant, so that they need to prove that there was consent, essentially, rather than the prosecuting having to prove that there wasn't consent. That's something that they're seeing coming through in the cases. It's very hard to get procedural fairness when the burden of proof has shifted. So that's something that judges are indicating is something that they're certainly seeing, that it's really now up to the defendant to prove that there was consent, and that's not the way that our system operates, and so they're indicating that there's an issue there in the way that the legislation has been written. And given the vast weight of the media involvement in consent, the presumption of innocence is already at risk when a jury is present. And it's leading to an increased request for judge-alone trials in the district court. That alters ultimately the right to be tried by your peers, which is a human right and a check and balance on the system and a rule of law principle as well. So there's quite a few impacts around those consent laws. The other thing is that there's limitations on sentencing. So judicial discretion is kind of removed from the equation as well, and aggravating and mitigating circumstances and the amount of mitigating circumstances they can take into account. So there is a standard non-parole period of 7 years if you're convicted of sexual assault without consent. So it's essentially a mandatory sentence, and that takes away that ability of our judges to create a sentence that is maybe more reflective of those circumstances around those two people. Also, a couple of the judges have indicated that they don't like that there is not some form of alternative program as well, an alternative pathway. Particularly, they're seeing mostly young men. There are young women being brought before the courts, but mostly young men. And they're talking about, well, they're a 19-year-old who's made a mistake and not sought absolute clarity. And if I send them to jail for 7 years, they're not a criminal now, but they're certainly going to be a criminal when they come out of jail after 7 years. So they're thinking about that future kind of problem that's going to cause for the community as well. So there's certainly lots of issues around the consent laws at present. We haven't seen enough. There's no data available from Buxar at the moment specific to the consent laws. I think that's probably still going to be a couple of years away, but there certainly is an increase in reporting of sexual assault cases. Now, whether that's linked to the consent laws or linked to just a greater awareness and a greater willingness of victims to come forward, we don't know as yet or at present. So the next thing as well that's kind of linked to that is that sexual assault matters tend to be a political hot button. They are something that the community feels very strongly about. And there's a risk of over-prosecution at the moment, and that's something that's causing a bit of friction between the DPP and the judges at the minute in the district court. There's a bit of a feeling that there are cases being sent to court that are sexual assault matters that don't have enough evidence, the weight of evidence is not there to get a conviction, and that perhaps shouldn't be before the courts. So there's two cases that I've referred to there from the last couple of years. RV Martinez, which that case reference I've got for you is a costs case. So a cost case is where the defendant basically tries to, when acquitted, applies to recover costs for their legal fees from the government, because it should not have, if it was deemed that it should not have really proceeded to court. So that cost case was presided over by Judge Newlands, and Mr. Martinez was accused of 4 counts of sexual assault without consent. He was arrested in June 21 and was refused bail. He was eventually granted bail in February 2022 after 8 months in custody. So there were 5 other men who were unknown to each other completely, that are all being accused of similar on other occasions by the complainant. And Mr. Martinez's trial commenced on the 23rd of November 2023 and concluded on December the 3rd, so it went for just over a week. And the jury acquitted him on all 4 counts after an hour's deliberation on December 4th. So costs were awarded by Judge Newlands in that case, who believed that that case should not have proceeded to court, that the evidence was certainly not strong enough, and that the complainant had a tendency to she had a tendency at that point in time, given that there were 5 other young men, to want to cover her activities at some point in time. I can't remember his exact wording, I apologise. But do look it up. It's an interesting cost case. You can find that on New South Wales case law. RVDS is another one for the New South Wales District Court. It occurred in a town on the border of New South Wales and Queensland in 2020. So the defendant was a man in his late 20s, and he was accused of 3 counts of sexual intercourse without consent. This case was actually found accidentally by police because the complainant tried to re-enter Queensland without a border pass, because it was in a time where you needed border passes to go over the New South Wales Queensland border. And at the border, she made an immediate complaint to police, and the defendant was followed up straight away. He admitted to consensual sex, submitted to DNA samples, but the whole time the complainant's story kept changing, had vast inconsistencies, lots of moving parts, according to the judicial officer, that were deemed to be demonstrated lies during the trial. He had no prior history, and his version of events was entirely supported by CCTV footage from the venue they'd been at, and text message exchanges between the 2 parties as well. So he was acquitted, and costs were subsequently awarded after that as well. So there's a resource efficiency issue there, given that we're paying for a court case to go ahead, and the court's time, and then costs having to then be paid by the the state government to pay for those legal fees. There's 3 judges particularly that have been quite outspoken about over-prosecution of sexual assault cases. Judge Wass, Lerv and Newlands are particularly outspoken about this at the moment, and it's causing friction with them and the DPP. And there's also been a costs application made in the last few weeks by Kirtley Beale as well in his sexual assault trial, and Judge Turnbull's presiding that. And that's expected to be handed down in June. So I think if we see another costs case awarded there, that will be an interesting outcome and may lead to some sort of change in policy potentially in the DPP in terms of prosecution. One of the issues there is that the DPP has been quite outspoken about, or the officers of the DPP have been quite outspoken about judges not having the role of providing that kind of feedback and not having the role to tell the executive what to do in terms of who to choose to prosecute. But we have to protect the independence of the judiciary because that's key to upholding human rights. And that is a check and balance on the executive that's being provided by the system. So the judiciary should be free to speak of issues in their judgments that are leading to issues of non-compliance with human rights obligations and also non-compliance with the law as well. That's their job to say, we're the ones that have to apply this law. It's not working in some way, shape or form. So that's something to think about. The BUGME directions, I don't know if anyone's familiar with these, but these are directions that relate to judges needing to consider the impact that a background of childhood deprivation and disadvantage has on repeat offenders. A majority in the High Court found that the effects of childhood deprivation do not diminish with the passage of time and repeat offending, and that a background of that kind has to be given a full weight in determining an appropriate sentence. And this stems from the case of William Bugby, who assaulted 2 prison officers, and he pleaded guilty to assault and intentionally causing grievous bodily harm to another while he was in remand. He was a 31-year-old Indigenous man from far western New South Wales with a very low life expectancy for men of Indigenous background. His childhood featured domestic violence, substance abuse. He's illiterate. He has a history of mental illness. He was first jailed at 13 and he'd spent more time in prison in his life than out by the time this particular case came before the court. So the appeal went all the way to the full bench of the High Court, and it was held that that offender's exposure to extreme violence and alcohol abuse can explain their recourse to violence when they're frustrated. And so if you have a repeat offender before you as a judge, that you need to actually take into consideration the circumstances of their childhood because it has an ongoing impact. So the reason for this is that the consideration reduces culpability in some ways, in some particular cases, but it can also equally support a lengthy imprisonment term based on community protection. And that depends entirely on what the judge finds or the judicial officer finds is the impact of that ongoing trauma. So it's a really good example of where precedent's been used to uphold conflicting rights of 2 different parties to a matter and to create some sort of consistency in outcomes for offenders regardless of their background, because this principle it's not just applicable to Indigenous offenders, it's applicable to all offenders. The no body, no parole laws are another area that have been under question because for all essential purposes, it's pretty much a retrospective piece of legislation. If we think about Chris Dawson, for example, given he was the defendant whose case essentially led to the formulation of the law, the no parole laws, is it fair, if we think about fairness and Equality, is it fair that he and others could be subjected to this parole test given their sentencing had already occurred when the law came into action, and it's been taken into account as an aggravating factor by a judicial officer that the body's never been found. And they may or may not have cooperated with police investigations, etc., etc. So there could be, in some instances, what a complication can be that there's mental health episodes experienced by defendants in the heat of that moment of the death and the hours to follow, where they may not actually recall where they've disposed of a body, called dissociative amnesia. That is a phenomenon that can happen, that can occur with offenders. So is that an appropriate punishment for someone that may actually have that kind of condition related to the offence? There's a lot of concern among advocates for people who might have been wrongly convicted, who are in the system as well. So that's also an issue. And Kelly Lane is probably the most recent. She applied for parole and was the first to be exposed to these laws. The decision's expected to be analysed for fairness eventually, but her non-parole period was 13 years and she'd been a model prisoner. She was convicted without forensic evidence, a body or any witness statements, but she was rejected on the grounds of the no body, no parole rules on March 22 by the State Parole Authority. There's a lot of former judges as well indicating that using this no body, no parole as a blanket rule for all offenders is dangerous and inappropriate, simply because the judiciary has to determine a sentence that's appropriate to the offence and the considerations of the case at the time, as is the case with all convictions. So removing that integrity without another layer of conviction, it undermines the confidence in the system, as well as punishing offenders that in another way. The other issue is that if we compare Lane and Dawson, for example, they're very distinctly different cases. So Dawson, there was forensic evidence, there was witness statements, there was a history of domestic violence. We didn't have all of that with Kelly Lane. So is it, we're not really comparing apples with apples, but we have a blanket rule for those two cases. So that's something to think about. How are we going for time? 8 o'clock. Okay. So the questioning of vulnerable persons and the use of LEPRA, there's a case there, R.V. Blake. Mr. Blake suffers from an intellectual disability and he was charged with driving occasioning death. He was a taxi driver in Wagga and hit somebody who was sitting on the road intoxicated at the time. And he thought he'd actually hit a kangaroo initially. He had two passengers at the time. They didn't realise it was a person that he'd hit as well. They went to a service station, they checked the vehicle, they saw it was damaged. He called his boss and said, I've hit a kangaroo, etc., etc. The question around this was about the fairness of the questioning of the person. There's lots of aspects and regulations built into the LEPRA to protect people with intellectual impairments and vulnerability in terms of making sure that their rights are represented correctly and that they're questioned in a particular way in the interview process. And if they're not complied with, judicial officers become that check and balance on whether that evidence is admissible. So in this particular case, Judge Lair found that after a particular question point, everything before that shouldn't be admitted and everything after it could be, essentially because of the way that this gentleman had been questioned. Experts had found that he was being asked leading questions using a leading kind of style and had made admissions that were not appropriate. So that covers off our offenders. I do encourage you to have a look at those cases and those case references. They're really interesting to read through, particularly I've tried to pick interesting ones that are a little bit different for you in that area. But RV Blake, they're all available in New South Wales case law. So just go to the website and put in the case reference and the year and you should be able to find it pretty easily. Okay, so let's move on to our complainants and victims. So if we switch our focus a little bit, if we switch our lens and we look at historical child sex offences, again, where we think about the last slide when we're looking at the offender's sort of perspective, if we look at the flip side of those historical sexual offences, what about the victims' rights? In this case, the victims were young men at the time. They were very young men. They were children, essentially. And they were immediately responsive after that, the next day, using the media as a non-legal approach to achieving justice for themselves, or some form of justice to themselves. They had an article the next day, quite an extensive article, in the Sydney Morning Herald, where they talked about how difficult it was as young men and older men to come forward and to be taken credibly. And they referred to it as the experience philosophy, that young men would have somehow benefited from the interaction or enjoyed themselves because they were gaining sexual experience. And so that was something that they were really vocal about. This really creates issues of equality amongst victims as well. So why is their experience no less valid than a female victim's experience, was part of their argument as well. So the law at the time was focused on male predators and male victims, and female victims. Females weren't set out as perpetrators in the law, and so that's what caused the problem, as we were talking about before. So there's also issues of justice for victims here in those less common crimes, and how responsive the law is. So how do we create a remedy for those victims that recognises the trauma of the offences committed against them and upholds their human rights in terms of having recourse, feeling safe, all that kind of thing? Again, if we think about consent laws and we think about the flip side, we have to think about looking at the rights of the victim. In terms of the rights of the victim that are being upheld by consent laws, there's certainly creating a focus on the rights to privacy, security of the person, bodily integrity, rights to enjoyment of the highest standards of physical and mental health, which sexual assault victims certainly do not enjoy. And so that's certainly Article 12 is ICESCR, is the standards of physical and mental health. And that's something that is certainly addressed by the consent laws and incorporated into the consent laws. If we think about ICAC and government overreach, so anti-corruption bodies are intended to ensure the integrity in the executive, government and judiciary is maintained. If we consider the role of New South Wales ICAC, their purpose is to investigate corruption of individuals in the New South Wales public sector, not private individuals. They have a really low rate of conviction despite thousands of investigations. So in their annual report from 2020/21, expenditure by ICAC was reported at $28.6 million, and there were 2,916 matters received and managed by ICAC. There were 7 people found of corrupt conduct in that time. There's no exoneration process if you've been publicly identified by ICAC as being potentially corrupt, and that essentially forces people into the justice system to seek remedy, because there is no exoneration and no clearing of their name, essentially no process to be followed. So the focus, if you can't get redress through the justice system and that doesn't work, then they have to take the matter to the UNHRC, so the United Nations Human Rights Commission. So the case that I've cited there is Mr. Sharif Khazal, a businessman who has interests in the Rocks precinct. He was investigated by ICAC, and the report was handed down in 2021, and they found that he could have engaged in corrupt conduct. He launched a Supreme Court case that ICAC had operated outside of their jurisdiction because he's a private individual, not an employee of the state. The DPP found that there was no case to answer for him, so he had not been prosecuted. In May 2016, the inspector of the ICAC, so that was 2011, in May 2016, the inspector of the ICAC had made recommendations that there should be an exoneration protocol to be developed, and that hearings of individuals should be in private, not in public, because reputational damage was definitely an issue. And then there was another subsequent report in 2017 by the acting inspector of ICAC at the time, and he found the same thing, that there should be an exoneration protocol, and that hearings should be private, not public. In August 2017, Mr. Kazal lodged a formal complaint with the Australian Human Rights Commission, but it's outside of their jurisdiction because this is a state-based body. So because the Australian Human Rights Commission is a federal body, so that was a jurisdictional issue there. So in August 2017, he submitted a complaint to the United Nations Human Rights Committee, and was represented by Jeffrey Robertson. They made a finding in July 23 that the New South Wales ICAC had breached his human rights, particularly his right to privacy, family, and a good reputation. So there were issues of fairness, issues of the right to the presumption of innocence, right to appeal, timeliness of the resolution, because that's basically since he was, so it started 2010 was the first newspaper article that appeared identifying him as potentially corrupt in the Sydney Morning Herald, and it was 2023 when the ruling came through from the United Nations Human Rights Committee. And there is still no exoneration of his name before ICAC. So there are issues there about different human rights. Another area of interest, which is probably mostly in the USA, but I think we're going to start to see it here if it's not already happening here, is the use of AI in the justice system. And that is something that is being driven by cost pressures, labour shortages, efficiency gains, all those kind of things. So there's a few different ways that it's being used in the US, but it's really leading to big rule of law and human rights implications, particularly with presumption of innocence. So facial recognition technology is one way that we've seen the justice system using AI. In America, it's been happening for about 20 years, and there's been reports of innocent people who have been convicted as a result of faulty AI or AI not identifying things correctly. There's several cases in Detroit where falsely accused people were identified by facial recognition technology, and they could have been convicted. They were convicted because the assumption of the police was that the AI technology couldn't get the identification wrong. But it actually did happen. So Robert Williams was the first man in the USA reportedly to be arrested after being falsely identified by AI technology for stealing watches. The AI technology was using poor quality CCTV footage to match with his license photo, and police just assumed the technology was right and didn't conduct any further investigation before investigating him. There's a few issues with that, but there's also an issue that there's an overrepresentation of African American offenders in the databases of the American justice system, and that it's been found to be creating false positives. It actually works far more successfully, interestingly, on identifying white offenders because there's much less of a representation in the justice system of white offenders. So that's an interesting anomaly. But in Australia, we're seeing Coles and Woolworths using AI technology to identify former shoplifters in store when they come into the store. And that's an erosion of the presumption of innocence, and it's creating a presumption of guilt, basically, each time a former shoplifter enters a store. So that's an issue there. Judgments for minor matters, such as traffic offences, are being trialled using AI. There's a trial period, I should say, going on for trials to have be conducted by AI. There's big discrepancies, though, in judgments between the AI judge and a human judge. In one case, the AI for a stealing offence gave a 2-year prison term, but a judge gave a 12-month suspended sentence based on submissions and mitigating factors. So there's a really big discrepancy there. So how do we build those parameters to account for jail space, to account for alternative programs, to account for mitigating factors, somebody's circumstances? How do we account for those things in terms of using AI in our justice system, and how does that impact upon fairness in the system? How do you build in, if we think before about our bugme directions, for example, how do you build in a childhood of trauma, or the fact that somebody lost their job and their partner lost their job and they were just trying to feed their kids by stealing for the 15th time because they were stealing from a supermarket? You know, how do we build those factors in? So that's a question at the moment in the USA. And then there's also issues about lawyers using AI as well. There's a case there that I've got for you, USA, in the USA, of Matter versus Avianca in 2023. There was a man suing Avianca Airlines for an injury. A trolley ran into his knee on the flight, a food trolley. The airline asked the judge in Manhattan, in the Manhattan court, to dismiss the case, but Mr. Matter's lawyers cited a number of different cases. So there was a 10-page brief with 6 decisions submitted by Mr. Matter's lawyers, essentially saying, yes, it should be heard. The judge and the lawyers for the airline could not find a single one of those cases because ChatGPT had made them up. So it essentially hallucinates cases when it can't find things. So the judge ordered that those lawyers that had used AI had to send the judgments to the judges that had been identified by the bot as creating them, and also had to pay a $5,000 penalty. So there's resource efficiency issues there and fairness issues as well. There is actually a judge in Northern Texas as well that's banned the use of AI by lawyers in any cases he presides. So as of June last year, he makes everybody entering his court, all of the lawyers entering his court, sign and certify that they did not use AI to draft their filings or to find cases, because he's found it to be so problematic. There's also a few cases being trialled at the moment, AI being used for legal representation in very minor matters as well, but it's very hard to find any information about that at this point in time. So that's something to keep an eye on. Okay, we're getting there, everybody. So in terms of society and community focus, if we look at that wider lens, and we look at issues of compliance and non-compliance and effectiveness of legal measures in protecting human rights, I want to look at the Closing Loopholes Bill really quickly. A lot of information has been coming out about this and various aspects of this, but essentially the Closing Loopholes Bills are intended to change work conditions to improve fairness and rights to private life of workers. For example, the right to disconnect is something to look at. So this actually follows the lead of Italy and France. They've had similar legislation since 2017, pre-COVID, where people were already kind of telecommuting quite regularly. And it was enacted, that legislation in Italy and France was enacted to prevent the blurring of the lines between home and work. Culturally for them, it's a very important definition. And this shows a recognition and promotion and enforcement of various rights related to the workplace, and it will improve fairness and equality between workplaces and the ability of workers to seek recourse from their workplaces that are encroaching on their rights. So that's an interesting thing to be looking at as well, particularly if you do workplace with your students. Environmental and cultural interests. This is a really growing area in terms of interest in human rights, and I think students really enjoy it too, enjoy talking about it. So we saw the Waratah coal case with the youth verdict in Queensland, where the application for the mining lease was refused by the Queensland Land Court on the basis of climate change impact and intergenerational equity. So President Kingham of the Queensland Land Court found that the granting of the licence would infringe cultural rights, the rights of the children, rights to life, property, privacy, home. There was a number of different things. The case is interesting because Queensland has a Human Rights Act of 2019. Has a Human Rights Act created in 2019. And Waratah Coal tried to argue that only individuals could bring an action under the Act, not incorporated entities, and Youth Verdict is an incorporated entity. So they tried to have that stopped on this basis. So we also have a more recent and very important case of Billy and others versus Australia. And that was heard and decided by the UN Human Rights Commission. If you haven't come across this case, it wasn't given a lot of publicity in Australian media. There was only 2 articles on it at the time, one on the ABC and one in the Northern Territory Times. But it's a really significant finding for all governments, and it puts them on notice, essentially worldwide, that states have obligations to their present and future citizens to prevent climate change and the impacts of climate change on human rights. So Daniel, Billy, and the other people involved in the case, they're all Torres Strait Islanders who took the Australian government to the United Nations Human Rights Committee for inaction on climate change, which has led to breaches of their right to life, the right to enjoy their culture, the right to a healthy environment, a number of different issues. The UNHRC found in favour of the applicants under Article 17, the right to family life, and Article 27, cultural rights of the islanders. So we've seen similar decisions in the last month or so made by the European Court of Human Rights. They ruled against Switzerland in an action brought by a group of women in their 70s that climate change inaction was impacting upon their health due to increased temperatures as well. There were another 2 cases brought against Portugal and France for climate change inaction, but their grounds were denied, so they were not successful. But there's also a case in the UK coming up as well against the UK government by a gentleman too. So there's lots of cases coming forward for climate change inaction. So there's really an issue here of present and future rights protection. So what it's doing is it's essentially creating a circumstance, an express circumstance, and decisions that mean that rights are also being viewed as intertemporal in nature, that they're not limited to just the present time frame, that they actually have a future implication as well. So you can add that to all the other I's you teach in terms of the human rights principles as well. In terms of the rule of law principles, if we think about the issues of intergenerational equity and the promotion and protection of socioeconomic rights are needed to support rule of law principles and make sure that they're actually safe. All of these things happening promote confidence in systems of governance and support the achievement of human rights and the achievement of rule of law principles. They increase democratic engagement, they keep the rule of law safe, they keep human rights safe. So there's something that we need to think about as well. The last issue there is the role of law reform in protecting human rights. And this is really something that has had a lot of conversation in the last few months about it, but probably over a much longer period of time, realistically. Looking at charters or acts of human rights. The COVID-19 legislation in Victoria, because there was a Charter of Human Rights there existing, so the creation of human rights legislation and charters are often heralded as being the key to protecting human rights, but we can see from some examples, particularly this one in Victoria, where this hasn't necessarily been the case. So the issue here is whether encapsulating human rights actually gives a government more control over what is and isn't recognised as a human right, and whether it makes it harder for promotion and compliance to happen for other human rights when there's a conflict between different human rights. So Victoria's Charter of Human Rights and Responsibilities Act was enacted in 2006, and the COVID laws that were created to instill lockdown and close borders, they symbolised a clash between Article 9 in that charter, the right to life and not be arbitrarily deprived of life, and Article 12, the freedom of movement. So there was also an issue of retrospectivity here. So laws were changed about entry to Victoria and Queensland while residents were away, and then they couldn't return in time to comply with the closure, and were locked out. So that retrospectivity didn't enable people to move freely in and out of Victoria, a right which was expressly given and expressly stated in the Victorian Charter of Rights. So the Victorian Ombudsman received complaints and released an investigatory report in December 2021, stating retrospective legislation should be avoided in a society governed by the rule of law. The Victorian Scrutiny of Acts and Regulations Committee, which is an oversight body that operates as an accountability safeguard for Victorian legislation. They have the authority to report to Victorian Parliament where they believe a legislative instrument has an unauthorised retrospective effect. What essentially happened in 2021, January 2021, is that the powers of that body were removed by the Victorian government, and that prevented residents of Victoria appealing decisions that impacted upon them, essentially through the COVID lockdowns. And what it did eventually was it created a lot of non-compliance, as we saw in Victoria. So that erodes that structure for the supports and the governance systems and essentially the rule of law. So respect for law is vital in gaining compliance with the law. So that's pretty much where I want to wrap it up tonight. So I just want to check the chat quickly.
Does anyone want to write questions on the chat, maybe, Justine?
Yeah, yep. I was just checking if there was any there, but I can't see any there. Does anyone have any questions at the moment? You can always feel free to email them through at another point in time as well if you're just done, given that it's 8:26. There's someone typing there, Sal. Thank you, everybody, for your time tonight. I hope it was helpful. If you really want if you have any questions or you think of any questions in the next few days or next week or whatever, please feel free to email them through to education at Rule of Law. The contact details are on the last slide of the presentation. Please feel free to look up some of those cases. They're really interesting reading. I think that you'll get just personal professional development out of them more than anything, even if you don't share them with your students. I think it's really important to keep yourself up to date, and I hope that they're interesting for you. Okay, I think everybody, if you want to leave now, if you don't have any questions, thank you so much for coming. All right, thanks everybody. I hope it was worthwhile. Thank you. Oh, thanks, Christine. That's very lovely. Thank you. Thanks, guys.
How about we end it?
Yep.